Folks will take their seats, and the first panel will come up. We'll get us started. Well, that announcement stopped conversation, which has been going on at a lively clip for a while. Hopefully it will resume again in just a few minutes. I'm Chris Schrader. I direct the public law program here at Duke, and I want to thank all our distinguished panelists, both the local ones and the ones who have come from out of town, for being here for a day of roundtable discussion. We are going to employ a format in which each panel will be moderated, in this case by my colleague Erwin Chemerinsky, and Erwin will pose some questions for the panelists in a format and a routine that either they've worked carefully out or will be entirely ad lib or someplace in the middle. But we'll have literally a conversation, a discussion among the folks up here in each session for about half of the time for the session, which will be 90 minutes each. And then we'll open the conversation up to the views, comments, queries of everybody else in the room. So ideally, by the end of each session, we'll be having something of a massive mud fight or a vigorous debate among all of us. And then we'll break and we'll start over again with the same format in the next session. So I'm going to just briefly introduce this panel, because we're getting started a little late, and ask you to rely upon the somewhat fuller biographical information that's in the conference materials, because if I did more for any of them, I'd be up here much too long, since there's such a distinguished group of people. We first have on my left Erwin Chemerinsky, many years at USC, just joined this faculty, a longtime scholar in constitutional law, civil liberties, federal jurisdiction, and lots of other topics. John Harrison from the University of Virginia, an equally distinguished constitutional law scholar, pointing out particularly his work on structural issues in the Constitution. Eric Muller from down the road, the University of North Carolina at Chapel Hill, who's also a distinguished civil liberties, criminal procedure expert. Neil Siegel, just coming to us here at Duke from a clerkship with Justice Ginsburg, and Adam Charnes, currently with Kilpatrick and Stockton, having spent time in both the Justice Department and clerking on the federal bench, and someone with a long-time interest in all of these issues of executive power. The topic of the first panel in particular are the trio of decisions the court decided at the end of last term dealing with detention and their larger ramifications. So without further ado, I will turn this over to Erwin, and we'll take it from there. Thank you, Erwin.
It's really a pleasure to be here. As Chris mentioned, our focus is on the three Supreme Court decisions from June 28th of this year: Hamdi versus Rumsfeld, Padilla versus Rumsfeld, and Raisel versus Bush. I know that everybody in this room is very familiar with them, and so what I'd like to do is focus immediately on the Hamdi case. If you recall, Yasser Hamdi is an American citizen who was apprehended in Afghanistan. He was brought to Guantanamo. When it was discovered there that he was a citizen, he was then taken to a military prison in South Carolina. The administration argued that he was an enemy combatant, and thus he could be held without judicial review and without due process. The Supreme Court in the Hamdi case focused on two issues. First, did the government have the authority to hold an American citizen apprehended in a foreign country as an enemy combatant? And second, if so, is he entitled to due process? Let me focus, panel, on the first of these questions. Was there the authority to hold Hamdi as an enemy combatant? The way I read the Supreme Court opinion, there were four different positions taken. Justice O'Connor, writing for plurality, said that it was permissible to do this because Congress's authorization for the use of military force after September 11th met the requirements of the Non-Detention Act that there be congressional authorization to hold American citizens. Justice Thomas, in his opinion, said that the president has the inherent authority as commander-in-chief to hold American citizens apprehended in foreign countries as enemy combatants. Justice Souter, joined by Justice Ginsburg, took the position that there was not a sufficient authorization for the use of military force found in the resolution adopted after September 11th. In part, he said there would need to be a clearer statement of permission to hold American citizens as enemy combatants. And Justice Scalia, in a dissenting opinion, joined by Justice Stevens, said that no American citizen can be held as an enemy combatant until and unless Congress suspends the writ of habeas corpus. It seems to me there's a range then of different approaches taken as to this first question. And I guess I'd begin by asking each of the panelists where they think the court should have come out among this range of choices, or if they think another option besides these would have been better. Maybe just go down the road to start. John?
Thanks, Erwin, and let me apologize if I caused the delay here by being a moment late. I was lost. Yeah, I think basically I agree with the plurality. I think that under the law of war, combatants are routinely held, that there is no reason to think that a United States citizen can't be an enemy combatant of whatever status, lawful or unlawful, and that the use of force authorization clearly contemplated the use of military force against Al-Qaeda, and something that contemplates the use of military force clearly contemplates that people will be detained just as they regularly are under the law of war. I think the dominoes fall fairly neatly there. I don't agree with Justice Scalia. I think Justice Scalia has fallen into the trap of taking pieces of history and attributing them to the Constitution rather than attributing them to the common law and the law of war, which I think is where other parts of them belong. So since that's a mistake, I think he's unduly constitutionalized some old common law mechanisms and principles. I think the plurality is basically right.
I think reviewing the decisions for this, I came down even more firmly than I had when they were initially released with Justice Souter, in that I think that the plurality's treatment of the Non-Detention Act is too short. It is a misreading of the Non-Detention Act, and it's more importantly a misreading of the history that produced the Non-Detention Act. The Non-Detention Act, for those of you who haven't read this stuff recently, was legislation passed in, I believe, 1970, I want to say, 71, that quite clearly was designed to prevent the recurrence of the incarceration of Japanese Americans during World War II. It was a time when an earlier statute authorizing executive detention arguably authorizing executive detention of citizens was lapsing, and there was some debate about whether simply to allow it to lapse or whether to take the further step of making clear as a legislative matter that the president may detain citizens only with the explicit authorization of Congress. What the plurality does, I think, in Hamdi is to read into the force resolution of just after September 11th an intent to reach the detention of American citizens that not only is not in the language of the resolution, but I don't think can fairly be squared with the serious congressional concern for the prolonged detention of American citizens that occurred 60 years ago during World War II as to Japanese Americans, and that the Congress was trying to prevent the recurrence of. So I think, if anything, Souter might have made a stronger case than he made for the relevance of the Japanese American experience, so I think the plurality gets that wrong, and therefore I would have been with Souter, I think.
Yeah, I would have been, at least as of today, with Justice Souter and my justice. But that's my bottom line. But rather than just boldly assert a conclusion, I should confess that I've struggled with it, and it concerns me that the longer I had time to think about these issues, the clearer they became, and the court doesn't have as much of an opportunity to do that as would be ideal with the press of the work at the end of the term. I originally found the plurality's logic persuasive. The authorization for the use of force just refers to using all necessary and appropriate force against, among others, persons that the president determines planned, etc., the September 11th attacks. Sure. And that language doesn't, by its terms, refer to detentions, and yet part and parcel of the conduct of war throughout history has been, if you can kill other people, certainly you can detain them instead of killing them, right? There seems to be a compelling logic there, even if it's a little bit gruesome. The reason why I don't think it's ultimately, the reason why I don't think that logic is ultimately persuasive is that, well, it's twofold. First, Justice O'Connor in the plurality makes clear that detention for the purpose of interrogation is not part of the law of war and is clearly not permissible. Whatever they were doing with Hamdi, it seems to me the reason why he's not in the POW camp in Afghanistan, but with Padilla and one other person in the brig, is because they want to interrogate him. In fact, the government and Secretary Rumsfeld was very forthright about what their purpose was. They don't want to subject him to criminal prosecution. They want to find out what he knows. That is not authorized by the law of war. So therefore, I wouldn't think that the AUMF, the authorization for the use of force, would validate the detention. The second reason, I think, has to do with presumptions and clear statements. It seems to me that if we're going to require a clear statement before Congress can abrogate state sovereign immunity and things of that sort, I hope we can all agree that the interests that are at stake here are of greater constitutional moment. And if that's the case, then it seems to me there should be a clear statement before the president has authority to detain people as enemy combatants. There is no clear statement. It refers to military force. It doesn't specify it. I think Congress never remotely thought about this. Then you can query, well, if they had thought about it, what would they have done? And the answer is, I don't know. And if you believe congressional authorization is required, and I do, then it seems to me that, and Congress is legislating against the background of the Endo case, which required a clear statement at the time they passed the Non-Detention Act, which I also think applies, then it seems to me that there's no authority here.
I agree with the plurality and with most of what, or all of what Professor Harrison said. I just make a couple of points instead of repeating. What Hamdi's lawyers argued, or they conceded, that the government had the authority to detain Hamdi on the immediate battlefield, but said once they moved him off the battlefield, the authority ended. The Non-Detention Act doesn't make any such distinction at all. It says the government cannot detain. Now, as a practical matter, it would be impossible for the government not to detain someone, particularly when they didn't know he was a U.S. citizen at the time. But it seems to me that that distinction between the battlefield and off the battlefield doesn't have any statutory basis. Second, with respect to the clear statement rule, it seems to me there's a difference between the 11th Amendment because there's a background principle of 11th Amendment immunity. And what the court has said is in order to make an exception from that, you need a clear statement. Here, the background principle is that you can detain enemy soldiers. And in fact, throughout history, the U.S. government and other governments have detained enemy soldiers who have been U.S. citizens. It happened at least several times during World War II. There are a couple of reported cases of U.S. citizens detained as prisoners of war. It certainly happened during the Civil War, even before the habeas statute, or habeas, was suspended. And the U.S. government treated Confederate soldiers as disloyal U.S. citizens, and obviously did not recognize the Confederacy as a foreign government. So I think in that circumstance, the background principle should be that, or assumption should be that detention is permissible in that narrow circumstance. Finally, I guess the only other point, or two other points. With respect to interrogation, I think it's absolutely correct that you cannot detain someone just to interrogate them. But if you are lawfully detaining them under the Geneva Conventions, interrogation is permissible. In fact, it's happened repeatedly. And during World War II, for example, both sides set up robust interrogation systems for captured enemy soldiers that were perceived to be of high value. Captured soldiers were routinely screened immediately to see if they're of intelligence value. During World War II, the Allies sent high-value detainees to special camps to interrogate them and so forth. So that's a routine part, an accepted part of treatment of prisoners of war under international law. And I guess the last point I'll make with respect to the Japanese detention, and I think that's not a very good precedent. I don't know what Congress was considering in the Non-Detention Act, but it's not a very good precedent, I think, for the treatment of Hamdi, for the simple reason that there was no, actually two reasons. First of all, none of the Japanese citizens who were detained unjustly for so many years were captured on the battlefield or near the battlefield. There was no particularized claim that any of them were actually disloyal or actually members of a hostile foreign army, as was at least allegations with respect to both Hamdi and Padilla. So I think the situations are quite different, and you certainly want a different set of rules for presumptively loyal American citizens and for an American citizen who hasn't lived in this country since he was a few months or a few years old and was captured at least near a battlefield, if not on the battlefield, and was allegedly captured carrying a military assault rifle.
I want to give everybody in the panel a chance to respond to each other. I just want to note that it's interesting that no one on this panel defends the Justice Scalia civil libertarian position. It's not that often I can say Justice Scalia civil libertarian position with regard to nobody can be held as an enemy, no American citizen can be held as an enemy combatant without Congress suspending the writ of habeas corpus. And no one is taking Justice Thomas's broad executive power position that there's the inherent authority under Article 2 to detain enemy combatants. Two panelists have taken the Justice O'Connor plurality position, and two have taken Justice Souter's position. And I guess after listening, I'd ask each of you the following. Eric and Neil, how do you respond to the argument that it's always been the authority of a country, including the United States, to hold enemy combatants as part of war, and that therefore was implicitly authorized when Congress passed the resolution permitting the use of force after September 11th? And also, if Hamdi could have been detained in Afghanistan without judicial review in the American courts, why should it be any different just because he was brought to a different place? Doesn't this give the perverse incentive to hold him in Afghanistan rather than bring him here?
I guess I would say that it may well be that there is, in Justice Thomas's position, something of value to respond to this question, which is that the power to detain somebody on a battlefield may inhere in the president's independent commander-in-chief authority, such that Congress couldn't take it away, under Youngstown, even if it wanted to. But we're not talking about that case. We're talking about a case of continued detention of an American citizen who is alleging, we are taking at face value in this discussion the government's assertion that Hamdi is an enemy combatant. But Hamdi's position is that he's not, right? Hamdi's position is that he was mistakenly taken. So on what basis, and that's, I would say, by the way, Adam, that's the basis, I think, on which the attempt to distinguish certainly the situation of Japanese Americans in World War II was not identical to Hamdi's, but it's much closer, I think, much closer than you depicted it to be, because it's important to remember that Japanese Americans were removed from a theater of operations. It's not like they were picked up, in Chicago. They were removed from the Western Defense Command. And they were removed from the Western Defense Command precisely because of the government's suspicion, not particularized as to most individuals, although there were some as to whom there was some particularized suspicion, but as to all of them, that at that time there may have been 112,000 saboteurs and spies roaming the West Coast, a place of military operations. So to say that, and so really I think that the situation of Japanese Americans is much more closely analogous to Hamdi than you depicted it to be. And that's precisely why I think you need to return to the question of the Anti-Detention Act or the Non-Detention Act. I think that act makes clear that even with, remember that the internment of Japanese Americans was ratified, or at least the exclusion of Japanese Americans was ratified by an act of Congress, and it was funded by further acts of Congress. Nonetheless, in 1970, the Congress said that this was a mistake that should be avoided in the future. The court in Hamdi, it surprised me that Justice Souter did not also make something of the Civil Liberties Act of 1988, which, in addition to awarding reparations checks to Japanese Americans, declared as a matter of legislative finding that not just the exclusion, but also the detention that followed was unsupported by military necessity. So how one can get from that legislative history to the notion that this vaguely worded force resolution authorizes sustained detention is frankly just beyond me.
Yeah, I mean, I read the language of the Non-Detention Act. It seems if you're going to be a textualist about it, it's pretty clear. It says, no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress. And so the question for me is, what does the authorization for the use of military force authorize? In terms of the background principle, to me, the 11th Amendment analog here is not so much it's always been the authority to detain, because it's certainly true if you're being detained pursuant to the Geneva Convention, you can interrogate as well. I would like to hear the argument that Hamdi has in fact been detained pursuant to the Geneva Convention. I don't think that he has. I mean, I also don't think that they're lawfully detaining him for other reasons, and as well, they're just trying to interrogate him. Query, why is he alone with Padilla and one other individual in the brig in South Carolina, as opposed to in a POW camp in Afghanistan? So I think the background principle here is what Justice Scalia is getting at, which is a very strong historical presumption that in this country you either detain people and subject them to the criminal process, or else you suspend the writ. The reason why I'm not prepared to defend his position is because while I think the history and the historical practice is extremely important, I don't find it by itself dispositive, especially in very different circumstances that we face today. Query whether the law in 12th century England would have been the same if you had weapons of mass destruction and the ability for one person to kill thousands of people. So even though I might find his conclusion congenial from a civil liberties perspective, it seems to me I can't pick and choose methodologies to suit the conclusions that I like. But nevertheless, that would seem to me to be the strongest background principle, especially if there's no persuasive argument that he's being detained lawfully under international treaty obligations. In terms of the dilemma about, well, if he can be detained in Afghanistan, why can't he be detained here? Or if he, or the contrapositive, if he can't be right, if he can't be detained here, then he can't be detained in Afghanistan. It seems to me that the question is one of statutory construction. Right? The Non-Detention Act points us to the authorization. The authorization uses the language all necessary and appropriate force. Detaining him in Afghanistan, following international treaty obligations, not just for purposes of interrogation, it seems to me much more likely that if he was detained there, it would be in a typical POW type situation. And if that were the case, I think people would be less concerned. But the notion that just because he can be detained in Afghanistan, he can be detained here, of all the various possibilities, that seems to me to be the worst one, without having Congress say anything to the issue.
And John and Adam, as you respond to Eric and Neil, their basic argument seems to be Congress passed a statute that said an American citizen can be held, detained, imprisoned, only pursuant to express authorization of Congress. Congress has never passed such a statute here, so isn't this impermissible?
Who's got the Non-Detention Act text to hand? I'm not looking at it because I have there's a point I want to make about it.
There, in the syllabus.
Yeah. It provides that no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress. It doesn't say expressly. And I would contrast it with, and the question here is how to reconcile two possibly competing acts of Congress, the Non-Detention Act and the Authorization of the Use of Force Act. And again, the logic of the Authorization of the Use of Force Act is I assume that it authorizes detention pursuant to the law of war of people who aren't citizens. The next question is, if you have similarly situated people who are citizens, does it matter? No distinction between the two drawn by the use of force resolution. The other point about the Non-Detention Act, not only does it not say expressly, it otherwise does not have a marker requiring that it be superseded only expressly. For example, it's not like the War Powers Resolution. The War Powers Resolution requires reference to the War Powers Resolution in order to comply with it. The Non-Detention Act isn't like that. It doesn't set such a strong default. It's just one statute to be compared with another statute, and indeed it just says pursuant to another statute. So I think the only question then is a question of interpretation of the other statute. Does it indeed authorize detention of citizens? And the question is, I would say, do they fall into the general category?
One other point I'd make, which is that I don't think it's that unusual that Hamdi was moved to the brig. In fact, I'm sure I think the government did that thinking that was of some benefit to him as opposed to being in Guantanamo Bay where he was where he was initially in what was very much of a prisoner of war type camp. I mean, don't forget, during World War II, many thousands of German, Italian, and Japanese prisoners of war were held in POW camps within the continental United States. It's not necessarily well known today. So the fact that he's being held in Virginia or in South Carolina as opposed to Afghanistan, I don't think makes a difference under international law, and I don't think should make a difference under the Non-Detention Act. I think the bottom line is that there's no indication in the Act's legislative history that Congress considered this situation. So I think what the court was doing, and this is sort of typical O'Connor, Breyer type jurisprudence, is looking at it as a practical matter. What do we think Congress probably was thinking about? What would they have meant to do in a situation like this, abstracting from the political and other considerations at stake? And I think it's hard to imagine that maybe in the context of the late 60s, it would be different, but it's hard to imagine Congress saying there's no authority at all. I'm not suggesting that they would think that the government was right, that the mob's declaration was sufficient. That's a question we'll get to in a few minutes. But as a question of authority to hold or not, it's just hard to believe that a majority of Congress today or back then would have said basically no, that an Italian soldier of U.S. citizenship in World War II, what this statute meant was once we take him off the battlefield, we have to let him go to return potentially to his army and fight against us again. I just don't think that's a very practical interpretation of the statute.
I want to move to the second issue in the Hamdi case. Is once the court said, with 5 justices agreeing to the conclusion that Hamdi could be held as an combatant, then the issue is he entitled to due process? And here I read the court dividing 8-1, with Justice O'Connor writing for, in essence, the court saying that Hamdi is entitled to due process, that the nature of due process is determined by applying the traditional Matthews versus Eldridge balancing test. The court weighs the importance of the interest of the individual, the ability of additional procedures to produce an erroneous deprivation, and the government's interest. And she gives some indication of what process would be required, but certainly doesn't resolve that issue. Only Justice Thomas seems to say that no due process is required. So I'm interested to hear from the panel, do you think due process is required here? And what's your view on the issue that the court didn't resolve? What process is enough here? What has to be provided to Hamdi or someone in his situation? Maybe we go the other order down the panel. Anna, if you want to start with this.
Well, I certainly think due process applies. The question, as I would formulate it, is what does the due process clause require here? Is it simply a several-page-long declaration containing hearsay or virtually all hearsay, or is it something more? And what I come to is obviously the underlying international law principles, the Geneva Conventions, don't necessarily reflect what the Constitution requires, but in the due process context in particular, I think they have a little bit greater weight. And the Geneva Conventions, step back a second, what Hamdi is arguing is that he wasn't a belligerent at all. He was an innocent aid worker or someone who was caught in a bad place at a bad time. The interesting thing for me is that the Geneva Conventions provide such a person with no process at all to prove that he or she is not a belligerent. Nothing at all. Article 5 of the Third Geneva Convention says if you claim that you're entitled to prisoner of war status and there's a question about that, there's doubt about that, you're entitled to some sort of military tribunal. But there's no reference at all to process in order to prove that you weren't a soldier or weren't a belligerent. And I think that's significant because the Geneva Conventions were written in just a few years after World War II. The people who wrote them were very familiar with the issues that arise in the detention of enemy soldiers during war. And I think there's nothing in the commentary of the Geneva Conventions, which is as close to legislative history, I think, as you can get, that suggests that they ever considered that such a person could say, I want a hearing to prove that I wasn't a belligerent, I was an innocent person caught on the battlefield. The fact of the matter is the United States alone had about 2 million prisoners of war during World War II, and it's inconceivable that none of those people were just innocently and mistakenly grabbed up as the armies moved across Europe and elsewhere. So it's important to me that the Geneva Conventions don't provide any process here. Now, for an American citizen, obviously I don't think is a good enough answer, and I don't think the courts, certainly I think 8 justices, as you said, would say that's not a good enough answer. But the fact that Hamdi is not disputed, he was captured on or near a foreign battlefield. All the indications are that he was an enemy soldier. At least there's prima facie evidence that he was. The decisions that he was an enemy soldier were not made by political officials in Washington or higher-ups in the Pentagon. They were made by soldiers on the battlefield whose job it is, whose expertise it is to make those decisions. And also the fact that those soldiers, the implications of providing rigorous due process protections to Hamdi, I think are very significant for battlefield conditions. The police officer on the streets of American cities is trained to comply with the 4th, 5th, and 6th Amendments. American soldiers are not. The police officer is trained to keep records so that if he has to go to, or she has to go to court to testify, he or she can do so and can recount what happened, exactly what happened, and keep evidence, preserve the chain of custody. Soldiers on a foreign battlefield are not trained to do so, and in fact, where they're required to do so, there would be significant negative implications for the conduct of the war. So I think all those circumstances necessarily have to play a part in what process is due. Was the mob's declaration by itself sufficient? I think that's a difficult question, and perhaps at some point it's fair, maybe sooner than the government allowed Hamdi to have a lawyer. At some point he has the right to challenge that, I think, through access to counsel. But I think that it's certainly due process clause. I don't see anything that says that has to happen immediately or anytime soon. And I think it's sufficient, given the history and the context, for the government to come in and make some sort of showing under oath to the court that Hamdi was in fact captured on a foreign battlefield and is an enemy soldier, enemy combatant, and that's good enough, at least for a long period of time.
And so to be specific, and I saw this message, with regard to the things that Justice O'Connor was discussing, notice of the charges, a meaningful factual hearing, a right to counsel, would you say that if there's another person in Hamdi's situation, all of those have provided? She also makes mention that the burden of proof might be on the detainee rather than the government.
Right.
Is that okay with you?
Yes, and the interesting thing is she didn't say when any of those things had to happen. She didn't say he had to get a lawyer right away. She didn't say what access the lawyer would have to his client, whether, for example, there'd be some sort of screening, some sort of national security, even a segregated unit of Army intelligence officers listening in, and anything like that. She left all the procedures that she talked about were at a high level. They were all very general. And she also said, most importantly, that the process that he would be entitled to could be solely a military process. And I think she hinted that if as I said, Article 5 of the Geneva Conventions doesn't apply in this context directly, but if the military had convened an Article 5 tribunal and that tribunal had determined that he was an enemy belligerent, she at least implies that might have been sufficient under the Due Process Clause.
Yeah.
What I find fascinating is that there is disagreement among the panelists, and yet we are all so much closer together than where I think people were when this case first popped up on appeal in the Fourth Circuit, in which the government's initial argument was basically that this is non-justiciable. That was the first argument. Then the argument became, well, okay, fine, it's justiciable, and the habeas applies, but not really. All you get to do is determine legally what's going on, not factually. Then they said, well, not really, you get the mob's declaration. So the government gave ground, but it seems to me that there's, if not a consensus emerging within the legal community, people who disagree about the extent of executive power and the power to detain are much closer together now than they were a few years ago. I thought I'd point that out. In terms of how you carve the court here, it's interesting to me. I don't know that you could say it's 8-1. I would say it's 6-2-1, because Justice Scalia, joined by Justice Stevens, really chides what you call the pragmatic approach of the plurality. He says there's a certain harmony of approach, and the plurality is making up for Congress's failure to invoke the suspension clause, and then it's making up for the executive's failure to apply what it says are needed procedures, an approach that reflects what might be called the Mr. Fix-It mentality. The plurality seems to view it as its mission to make everything come out right, all in caps, rather than merely to decree the consequences. So I just think Justice Scalia and Justice Stevens joined him just doesn't want any part of this. So I don't think he would say no process applies. I think he would say that we don't even get to this question. But I think he would take exception to being grouped with the rest of the court. In terms of what process is due, where I would look is not so much to the Geneva Convention. I'm going to cabin my comments, which is going to be subject to criticism, to the situation in Hamdi, which is a U.S. citizen held within the territorial jurisdiction of a federal court. To me, what you look at is the habeas suspension clause in the Constitution, which is a constitutional moment. And the question is, if Congress hasn't suspended the writ, and everyone agrees Congress has not, then there has to be an irreducible constitutional minimum that's at stake there, right? That if Congress doesn't suspend the writ, the right of habeas means something. And that's where I would look to determine what sort of process is due. And it doesn't necessarily mean that irreducible constitutional minimum coincides perfectly with the habeas statutes and all the typical procedures in habeas proceedings. But I think there has to be access to counsel, or else the whole thing is a charade. And you can question whether it should be monitored, whether it should be limited, whether a certain amount of time needs to pass. But the notion that there can't be access to counsel is just, to me, a way of saying that there's really no proceeding going on at all. There has to be a neutral fact finder, right? There has to be notice of the charges and ability to refute. The burden of proof I haven't worked out. I'm troubled with reversing the traditional presumption. I don't think it would be tragic if that happened, because if someone is innocent, if someone's a relief worker, it seems to me that if you have access to counsel and sufficient access to evidence, that could be overcome. But it's not clear to me why you would reverse the burden. Military tribunal, that to me is sort of the greatest concern I have with the waves Justice O'Connor makes at the end of her opinion. Not saying that it's perfectly fine, but it might be. And there, the question to me would be whether there's any access to federal courts on appeal from the decision of a military tribunal. It seems to me is all you have is a military tribunal, even pursuant to the Geneva Convention, then I'm not sure how the writ of habeas corpus has not been suspended. I don't know that you can conceive the writ as being vindicated solely within the context of the military tribunal.
Yeah, I think that what's becoming clear is that we've sort of got two core principles here at either ends of a spectrum. One of them is the one that was mentioned earlier, which is presumably the raw power to immediately detain a combatant on a battlefield, and at the other end, of course, the model of habeas as to how the entitlements of an American citizen detained in the United States. So it seems to me that the notion that there's a fairly clear sort of sliding scale that one can use here for due process, and it's, where are we along that continuum? Nobody's going to argue that a person has a right to appointed counsel, in a trench on a battlefield. But as time and place move away from the battlefield and away from the circumstances of the person's detention, it would seem to me that the government's arguments for denying or for watering down the model of habeas diminish, and the citizens' interests in securing those increase. So to me, it seems like the answer to the question of how much process is due is probably going to be different in different times and at different places. But certainly when a person is held in the brig in the United States 2 years after the initial apprehension on a battlefield in Afghanistan, it seems to me that the government's claims for a necessity to deprive that person of counsel, to shift the burden, to deprive the person of notice if in fact the government were seeking to do that. It's hard for me to see what the basis of that could even be, whereas it seems to me the citizens' interests in that time and place are pretty much at their apogee. So to me this seems like a sliding scale of time and place, and it's a practical one that would be functional. Surely the military, we know that the military has the ability to provide more process for individuals than it provided for Hamdi. I mean, look at the fellow who, just behind a battle line, I don't remember his name anymore, but just after the invasion, you'll recall that there was an American serviceman who heaved a grenade into a tent where some of his colleagues were gathered, and I believe killed a few of them. I have to assume that the military justice system kicked in at that point and accorded him the rights under the military justice system. That's close to a battlefield, okay, and it's close to battle circumstances. Now, my argument is not that Hamdi would be entitled to the that Hamdi is entitled to the protections of the military justice system. It is simply to say that we should be slow, perhaps, to credit the claim of military impossibility to accord certain basic rights to people near a battlefield. I guess that's the reason I bring it up.
I think that there are three questions here overall, and right now we're talking about sort of the one in the middle. The first one we talked about is the substantive question of the right to natural liberty and how it's modified by the law of war. The second question is what procedures are needed to determine whether somebody is substantively subject to the law of war and so has his or her natural liberty qualified by it. And the third question, and I think it's the third one with respect to which habeas mainly comes up, is the structural question. Which branch of government is primarily responsible for conducting those procedures? And when you get to court, how much deference should the procedures that take place in the executive branch be given by the court? I think that the procedural questions, the ones in the middle, are the hardest, and they're the ones about which I have the least confidence. What Justice O'Connor said seems reasonable to me, but a lot of things could seem reasonable to me. I don't think it's easy to get our bearings on this. I want to say something about the third one, the structural issue, specifically having to do with habeas. And I want to make 2 points. One, I want to disagree a little bit with Neil. I don't think the fact that habeas is available is by itself going to tell us very much, because it is a common phenomenon in habeas that finality principles, say for example the finality of criminal judgments that are being challenged on habeas, which is a collateral attack on a criminal judgment. Criminal judgments almost always get some kind of finality in habeas, and at various times under various habeas rules they've gotten extremely strong finality. Finality principles, that is to say, apply in habeas and can keep the habeas court from independently redetermining questions. And if it is true, as a matter of the law of war and the way the constitutional structure works with the law of war, that the executive branch gets deference when it is making decisions pursuant to the law of war, and it may or may not be true, but if it is, then it can get deference in habeas, just as an earlier criminal conviction can have finality in habeas. So the availability of habeas itself, I think, doesn't tell us very much. The other, which means we got some hard questions, and that's not going to answer it. The other thing I want to say about habeas is that I think the idea of suspending the writ, I'm surprised that Justice Scalia seems to regard suspension of the writ as a really good solution for this problem on the part of Congress. Because all that suspension of the writ does is take away one particular remedy. It doesn't change the substantive rules of the application of the law of war to people's rights to natural liberty. It doesn't make it lawful to detain somebody. It just keeps the courts from granting one particular remedy. And I was especially surprised to see Justice Scalia, who has on other occasions, and I think quite rightly, emphasized the importance of the independent constitutional obligations of the other branches when they act free from judicial review, to think that it is somehow open season when all that's happened through a suspension has been that a particular remedy has been taken away, but the substance of things hasn't been changed. So I don't agree with him and agree with those who say that suspending the writ is something that can make a major change. It's something that makes a minor change, and I think is most appropriate in extreme emergencies, but not in the kind of situation we're dealing with here. Yeah, maybe on the battlefield, maybe during a riot, but suspension of the writ, I think, is not really that large a component of all this. I
want to put on the table the Padilla case. As everyone here knows, Jose Padilla is an American citizen who was apprehended at Chicago airport in May of 2002. He's accused of plotting to build and detonate a dirty bomb in the United States. He's never been indicted or charged with any crime. The government takes the position that he can be held as an enemy combatant. He was taken briefly to New York, where he was held as a material witness, and the action was brought on his behalf there. He was then transferred to a military prison in South Carolina. The action proceeded in New York, and in December of 2003, the Second Circuit ruled that there was no authority to detain him as an enemy combatant, neither under a statute nor under the president's inherent power. As you know, the Supreme Court 5-4 ordered that Padilla's case be dismissed on jurisdictional grounds. Justice Scalia, writing for the court, said the habeas statute requires that a habeas action be brought against an individual who has custody over the detainee. In other words, it has to be brought in the district where the person is being held. That would here be South Carolina, not New York, so the case was dismissed and Padilla would have to start all over again. Now, I'm not interested so much in having the panel discuss whether Scalia is right or wrong on the jurisdictional question, but the question of, is there a difference between an American citizen apprehended in the United States and an American citizen apprehended on a foreign battlefield? And as we talk about this, I think it's notable, Justice Stevens, in footnote 8 of his dissent, expressly said that he agreed with the Second Circuit that there was no authority to hold an American citizen apprehended in the United States as an enemy combatant. Justices Souter, Ginsburg, and Breyer agreed with that. As we've been talking about, Justice Scalia, in dissent in Hamdi, said there's no authority ever to hold an American citizen as an enemy combatant unless Congress suspends the writ of habeas corpus. Does that then mean that there's clearly 5 votes that Padilla can't be held as an enemy combatant? And more important, is that the way it should be? John?
Yeah, I'm not sure about the vote counting thing, and anytime you're counting in particular O'Connor's vote, you have to tell her exactly which situation you want her to say something about. So I'm going to avoid speculating on that. I do think that Padilla's situation raises a very difficult question, although I don't think it's properly captured by talking about in the United States, out of the United States. I think those are actually proxies for another and more difficult question, which is the difference between an enemy soldier and a terrorist, and to what extent can you regard a terrorist as a combatant. What Padilla is accused of doing is an act of terrorism. It's not like war fighting, but it is nevertheless something against which Congress has authorized the use of force, and that is an awful lot like war fighting. I think one of the big things that is going on now is the adaptation of traditional principles of the law of war to terrorists. I think that in principle, it represents a series of difficulties. I think that in principle, terrorists can be and should be subject to the law of war in a lot of ways. But I think that's the question, not the inside outside the United States. Those are rough approximations of what is the real question, which is the difference of different kinds of organizations that threaten the use of force, different mechanisms that can be used to deal with them. So I would try to move the focus away from that and toward the difference between armies and terrorists.
Let me just ask a quick follow-up. Could McVeigh and Nickel have been held then as enemy combatants? What's the difference between what they were doing and, say, what Padilla was planning to do?
I would say very briefly that I think probably one of the crucial differences is the nature and extent of the organization involved. That as you move from a couple of guys with some ammonium nitrate to an organization like Al-Qaeda, you get towards something that is more like a state, more like a government, and hence more appropriately dealt with like a hostile state or a hostile government than are people who are just criminals. And I think one of the hardest questions is, how far along that spectrum do you have to go? But I think the spectrum is about the nature of the organization that you're dealing with.
I think John's depiction of the way in which the law is being pressed to transform here by the nature of unfolding events is exactly right. It seems, given what I've said before about how I think that once the person apprehended overseas is no longer overseas, and once time has gone by and it's no longer in the heat of battle, that person's entitlements approach those of a citizen apprehended in the United States. It won't surprise you that I don't think that there ought to be a big distinction between the situation of Hamdi and the situation of Padilla. I do think, though, that precisely for the reason that John suggested, this even more so than in the context of Hamdi, where you have a person apprehended, or at least allegedly apprehended, carrying an AK-47 and affiliated somehow with troops that are doing something that looks like what troops have done over the course of history on battlefields. Whereas here you have somebody who's coming in to launch, or allegedly seeming to prepare to launch some sort of terrorist attack domestically. It's that much more important that Congress speak, that the courts not be the ones who, in the Mr. Fix-It way that Justice Scalia sort of derides, are going to sort of come in and kind of make up new rules for us all to live by about how to take older principles that have come to us from the law of war and convert them to use in an age of terrorism. So here even more so than in Hamdi, I would argue that anything that you might think that applies in Hamdi as to the need for congressional authorization or clearer congressional authorization than the Force Act required applies in spades to Padilla.
Yeah, I will count votes. It seems to me not as perilous to do when you're not depending upon Justice O'Connor's vote, or Justice Kennedy for that matter. It seems to me clear as day that there are 5 votes for the proposition that Padilla's detention is not authorized. You have the 4 Padilla dissenters, which includes Justice Breyer, and you have Justice Scalia. That's 5 votes. It doesn't seem to me to be controversial. In terms of the merits, I want to disagree with John. It seems to me that the primary question is in the United States versus out of the United States, because in the Padilla case, the power the government is asserting is downright frightening, and I don't think that's a dramatic overstatement. The government's rationale would apply just as well, literally, to you and me walking down the street in Durham. That by the president's authority, you are an enemy combatant, and everything else follows. And all the facts about what you really are, and are you a terrorist or a criminal, and what's your organization, that all is supposed to come up later on once you've been detained and put in the brig, even though your access to counsel and your access to witnesses and your access to evidence is all really put in question. So it seems to me what Justice Stevens is saying in dissent, which is what makes this case different than others, is a probably unprecedented threat to the individual freedom of every American citizen. And so it seems to me that that is the most important question. I think there are also important questions about enemy soldiers and terrorists and criminals, but to me, the reason why the Padilla case matters so much is because you have not just an American citizen, but an American citizen in the United States. And how do you distinguish that case from you and me living here? I don't know what to do with that. So I do think that matters. Now, in terms of how it matters, I agree with Eric that it shows why it's so much even more important for Congress to speak to this issue. I think the irony of these two cases, when you put them together, is the government's claims, it seems to me, are in a sense more legitimate with respect to Padilla, because by all measures, it seems, or by all counts, from far as we can tell, he's a much more dangerous person. Even if the stipulated, even if the government's facts and how they are taken as true, he's one of many people with an AK-47, right, fighting in Afghanistan. Padilla is coming here to plant dirty bombs and blow up buildings. And so it seems to me that there is a real interest in detaining him and even in interrogating him, despite what I said earlier. So it seems to me that the distinction matters, but it doesn't matter in a way that somehow gets people like Padilla off the hook. I think it matters at least in the sense of requiring Congress to really speak to the question carefully.
Well, I'll engage a little bit of vote counting, and I wasn't there at the time like Neil, but just from my experience clerking there, and from more generally, I don't think you can treat footnotes in dissenting opinions with respect to the binding effect on people who joined the opinion but didn't write it the same way you can footnotes in majority opinions. And there's a number of reasons for that, but we don't know when footnote 8 was added to that opinion. It could have been after Justice Breyer joined it, and I don't think subjectively, and I should add, in my experience from a clerk there, it was very rare. In fact, I don't think it ever happened that a justice who joined an opinion complained about a subsequent change to that opinion after the fact, or certainly I don't recall ever seeing anything like that. More fundamentally, I just don't think I don't think a justice who joins a dissenting opinion necessarily binds himself or herself to every jot and tittle of the opinion. And I don't add it to the fact that I'm not sure in the text of the Non-Detention Act there's a difference between being detained in the United States and being detained in Afghanistan. I think it's reading a little too much to say Justice Breyer, based on that footnote alone, who's joining the opinion containing that footnote, would vote to make five votes for Padilla. I do agree with Neil, though, that to me it makes a big difference that Padilla was detained at O'Hare Airport and not in Afghanistan. And just as on a practical level, the fact that someone is captured in Afghanistan provides at least some indicia of reassurance that there's no government oppression and tyranny going on, which is not the case if someone is picked up walking through the international terminal in O'Hare or down the street in Durham or elsewhere. And I think for that reason, it is a much scarier prospect when someone is picked up detained in the United States than in a foreign battlefield. The final point I'll make, I guess, is that I'm not sure I see as big a distinction as others do between terrorism and war fighting. And I go back to the Quirin case, which is the World War II era case for that. The detainees in Quirin were landed on the continental United States by two changing into civilian clothes and blowing up domestic industry that was used in the warfighting effort. And I think using dynamite to blow up a factory is not terribly different in kind than what Padilla allegedly was plotting to do. I think that sort of behind the lines sabotage in traditional war is directly analogous to what Padilla was up to. So I don't quite see the big distinction. I think there obviously are distinctions. Among other things, the Querens saboteurs were landed via a military vessel. They wore uniforms that they ineptly buried in the sand, so that there are just clearly distinctions. But I think those may be distinctions of degree, not kind.
I want to ask the panel to briefly talk about the third case from June 28th and then open it up for questions. And that's, of course, Raisel versus Bush that involved the Guantanamo detainees. As everyone here knows, over 600 individuals have been detained in Guantanamo since January of 2002. The administration takes the position that no court in the United States has jurisdiction to hear their habeas corpus petition. That was the conclusion of the D.C. Circuit in Raisel versus Bush and Alota versus the United States. The D.C. Circuit relied on a 1950 Supreme Court case, Johnson versus Eisentrager. Johnson versus Eisentrager involved a number of German individuals who were apprehended in China during World War II for aiding the war effort against the United States. They were tried in a military commission. They were convicted. They were then taken to a military prison in Germany. They brought a habeas corpus petition in the United States, but the Supreme Court ruled that the federal courts did not have jurisdiction to their habeas petition. The D.C. Circuit said, based on Johnson versus Eisentrager, that those in Guantanamo didn't have access to the federal courts either for habeas corpus. The Supreme Court, in a 6-3 decision, reversed. Justice Stevens wrote for the court here. Chief Justice Rehnquist and Justice Scalia and Thomas dissented. Justice Stevens distinguished Johnson versus Eisentrager. He pointed out that the individuals in Johnson versus Eisentrager had received a procedure, a military commission trial, but those who would be held in Guantanamo were given no procedure. He said that Guantanamo is functionally under United States sovereignty, a point that Justice Kennedy emphasized in his opinion concurring in the judgment. The conclusion of Raisel is that federal courts do have habeas corpus jurisdiction to hear the petitions of those in Guantanamo, though if the courts did not decide and express in the last paragraph of the opinion left open what process has to be accorded to these individuals. So I'd ask each person on the panel to comment. Should those held in Guantanamo have access to the federal courts through habeas corpus? What kind of procedure should be accorded to them? Eric, do you want to start this time?
Sure. I think that the court answered the primary question correctly, which is to say that I think that the individuals at Guantanamo should have access to the courts, and that the question of what process they're entitled to needs to take account of the realities of the situation that they're in. Again, I come at this, I think, somewhat skeptically from as to the claim that the circumstances of their detention would preclude anything that we might reasonably recognize as the kinds of trial procedures that we accord in other habeas contexts. There's nothing evident to me about the circumstances in Guantanamo, 90 miles off our shore, that would make the situation there so terribly different from a place that's 90 miles north. So I have to confess that I have not thought through fully the intricacies of exactly what the procedure ought to look like, but I certainly do come skeptically to the issue as to the claim that it needs to deviate significantly from what we might ordinarily accord in a habeas context.
Neil?
I think the question you asked is a difficult question. I think the question I'll answer first is, to me, an easier question, which is whether Eisentrager is controlling. Justice Scalia accused the court of basically overruling Eisentrager without saying so and really hurting the government because the government had reasonably relied on Eisentrager to its detriment. That was a big part of the reason he suggested the government went there, is that they wouldn't have to deal with habeas proceedings. And it does seem to me that Justice Stevens makes lots of noises in lots of directions. Justice Kennedy, who concurs in the judgment separately, seems to me has a, by itself, persuasive dispositive distinction between Eisentrager and the situation at Guantanamo, which is that it is whatever you want to say, a functionally indistinguishable, effectively U.S. territory. Right? There's a lease agreement there. It's sort of an unusual arrangement. But if the U.S. law doesn't apply there, then no law applies there. Certainly, Cuba law doesn't apply there. That's very different than the situation in Eisentrager, when you have people fighting in China brought to Germany, and they're incarcerated in Germany, but there's no notion that somehow it's U.S. law or that there's no German law in existence in the background. So it seems to me you have a persuasive legal distinction for what's going on in Guantanamo. In terms now, just as an original matter, putting that aside, should there be access to habeas? Insofar as it's effectively U.S. jurisdiction, I'm comfortable saying yes, there should be. The reason why I think it's a difficult issue is because of what I view as Justice Scalia's very reasonable concerns in his dissent, which is it can't be the case that you can have routine access to the federal courts through habeas proceedings for POWs all around the world. Right? If the fact that it's effectively U.S. territory doesn't make a difference, then it shouldn't make a difference in their Afghanistan or Iraq or where have you. And that's contrary certainly to our legal traditions and contrary to sort of, I think, how the world should be. So I'm more comfortable with saying that in the Guantanamo cases that there should be access, but I think it's a very difficult argument to sustain, to say just as a general matter, wherever these folks are, no matter what the circumstances, the courts are open.
Well, I think it's certainly true that Guantanamo Bay is different than, say, a U.S. military base in Germany today with respect to the rule of law, and that if U.S. law doesn't apply on that base, then German law would apply. I'm not sure what law would apply in the Green Zone in Baghdad. I don't think there's Iraqi law that, as a practical matter, would apply. So I'm not sure there's a distinction between people held there and held in Guantanamo Bay or in Afghanistan, where I'm not aware that there's an independent Afghani legal system and law that, as a practical matter, can apply to U.S. military bases in Afghanistan. And I think the Stevens opinion, as Neil said, throws up a lot of stuff. But I don't think it's his rationale, under his rationale, it makes a difference whether the base is in, whether the U.S. has functional sovereignty over Gitmo versus a base in Afghanistan or South Korea or Iraq or Germany. And I don't think it makes a difference for his rationale, the fact that in Eisentrager, the habeas petitioners were convicted in a military tribunal. That seems to me irrelevant under the habeas statute. So I think the implications of his opinion are quite broad and far-reaching and troubling for the reasons that Neil said, and I think that's why Justice Kennedy broke off. But there were 5 votes for Stevens' opinion, and we'll see how it plays. Now, of course, Rasul is a statutory case that Congress can overrule, and that's the escape valve there, is that if habeas petitions start getting filed by detainees in Afghanistan, and if and when there's another war, as a practical matter, it would be difficult because they need access to at least the mails, to mail a handwritten, Gideon-type petition to federal court. But if that starts to happen, Congress can fix the problem. So, in a sense, this case presents less far-reaching problems than Hamdi and Padilla do, which to the extent that they're constitutional issues, Congress has a much more limited role to play.
First, I want to observe that I do like the conclusion that if you compare Rasul and Padilla, you realize that you're much better off in Guantanamo than in the Fourth Circuit, which is probably not surprising. I do think that if Eisentrager was right, and I'm not sure if it was because I've never figured out what I think about the interaction among the territorial jurisdiction of the courts, the immediate custodian rule, and the suspension clause. But if Eisentrager is right, I don't think Rasul is right, because I think that the best argument in favor of it is the functional sovereignty idea, and I'm very uncomfortable with that. I'm very uncomfortable with the fix-it people sort of sorting out questions like, well, how do we treat these different areas that are, in some important technical sense, not sovereign U.S. territory, distinguish the green zone from Guantanamo Bay and other areas in which the United States exercises various kinds of authorities? What if the plan for the United States to put a facility on Diego Garcia is implemented? In that area, I would much prefer bright lines about sovereignty and not the courts deciding what's sort of sovereign and what is not sort of sovereign. I do want to agree with Adam and Eric on one point, which is in this area and in a lot of these areas, what the primary thing we need is some action from Congress regarding, for example, the habeas jurisdiction of the courts in situations in places like Baghdad, for example, and similar context. We need some legislation concerning the treatment of people like Padilla. Yeah. Under what circumstances should somebody be treated as an enemy combatant? About the question, how close to an army does an organization like Al Qaeda have to be subject to the law of war? There are a number of areas in which Congress should act. The habeas statutes are one of them. I mean, they would be a good place to start, but they would not be a right place to end, because there are other issues on which Congress really needs to come down and do something.
Let me open it for questions. Scott?
Let me take us back to your discussion of the difference between Hamdi and Padilla. And I would ask all of you, do you see a particular significance in the fact that Hamdi was always within the military chain, from the time he was captured until the time he was taken to Guantanamo Bay, and then upon his claim of American citizenship whisked to Norfolk? He was throughout that process within the hands of the military. Padilla, on the other hand, when he was arrested in O'Hare, was almost for 30 days under a material witness warrant, and in fact had, if I recall correctly, almost 16 hours of conversation with Donna Newman, which seems to me a striking difference between Padilla and Hamdi. Is that of significance to you?
I will take the first crack at that, which is I don't think so. And the first thing I'm thinking about, my recollection is that the Quirine defendants were arrested by the FBI, weren't they?
But there's, I think you've already acknowledged that there's a clear distinction, John, between the 8 German combatants getting off the submarines in 1942 than Padilla. The fact that they were wearing uniforms but took them off made them unlawful enemy combatants under Stone's opinion. But I don't think you can draw that comparison with Padilla, because they weren't held in material witness status at all. They were always headed to a military commission on Roosevelt's order.
Yeah, I do think there is a difference. Whether it's dispositive, I don't know. We'd have to think about it. I mean, one obvious difference is that the government's primary rationale is an interest in interrogation. Right? We can't let these people have access to counsel, because what do you do when you introduce a criminal defense lawyer? Don't talk, and it's over. Right now, given that he's had, I don't know how many hours, but certainly several conversations with Donna Newman, by the time the military takes over, it seems to me that the persuasiveness of that rationale is significantly diluted. I also think there's a fact-bound aspect to Padilla that makes quite a bit of difference, and this is in Justice Stevens' dissent, which is the government, in the next parte proceeding, asked Chief Judge Mukasey in New York to vacate the material witness warrant because the military was taken over. And the judge did that, and the military whisked him away before his counsel, Donna Newman, was even told. If she had been told, certainly she would have filed the habeas petition immediately in New York. And then the argument that it wasn't properly filed would be very difficult to sustain. And what Justice Stevens is saying, and I think it's persuasive, is do we really let the government get the benefit of its acting against the normal proceedings, in which you let the counsel on the other side know what's going on and get this person into military jurisdiction before a habeas proceeding could be filed? So I think that's one way to handle the jurisdictional issues that the majority found dispositive in Padilla.
I'd also just note that because of the posse comitatus restrictions and what the military can do within the United States itself, as a practical matter, it's probably always going to be the case that a terrorist within the United States will be detained initially by civilian police authorities, federal or state. That seems at least to be a much more likely scenario. I'm not sure what, as a practical matter, either under the the legal regime or as responsibilities parceled out, that the military could have or should have been the ones to take Padilla at O'Hare Airport. I'm not sure that is something we would want, even if it were permissible. I think there are perhaps even greater risks than happening initially. So, but I agree that with Neil, that for me the big distinction is that Padilla did see a lawyer. He did have access for a lawyer for a month, and that does dramatically undercut the interrogation rationale the government relied on.
I just wanted to note that it's not, there's an enormous precedent for American citizens being apprehended initially by the military, and that's, of course, the situation of Japanese Americans in World War II. They were apprehended by the military, held by the military, and then transferred to civilian authority, as opposed to the other way around.
Please.
I did, and the answer to this may be unknowable, but I'll ask it anyway. While Razul was under consideration, as everyone knows, these OLC memos surfaced, and one of the arguments in one of the memos respecting the application of a federal statute on torture abroad was that Guantanamo Bay was not within was within the functional sovereignty of the United States. Therefore, this statute on torture abroad didn't apply. And I'm just wondering whether the court, in your sense, whether the court thought the executive branch might be playing games, and therefore whether its decision on separation of powers principles might be influenced by its sense that the executive branch couldn't necessarily be trusted to comply with constitutional norms on its own, and the courts needed to step in and say, wait a second, you guys can't play games with this sort of thing.
Yeah,
You were there.
Yeah, well, I certainly have no license to speak on behalf of sort of what the court thinks. I think it's there are two separate questions there. There's does the court think the executive branch is playing games, and can the executive branch be trusted? Right. I think there's certainly a plausible argument that the day Padilla is being argued, and Paul Clement says, well, this executive doesn't use torture, and then that night the news breaks, right? You can say all that unfolded, right? It's hard to, it's certainly a plausible argument. It's possible that could affect people and how judges are people, right? That there may be reason that just like in Rasul, right? I mean, people at the Office of Legal Counsel and the Department of Defense were so outraged at the arrogance of the judiciary for doing what they did, and well, if they had set up reasonable military tribunals a year or two ago, right, we wouldn't have gotten to this point. So I think there's lots of suspicion in American society about whether they can be trusted. In terms of whether the government is playing games, I can't say what justices are thinking. I don't think it's the case that the government is playing games. In fact, I would bet a lot of money that Paul Clement and Ted Olson had no idea what was in those OLC memos. And I read papers and articles in the Post that they were outraged they were not told about it. So it seems to me they are too good as lawyers. They're too responsible as executive officials. They feel too much fidelity to the court as an institution to know that the government is arguing one thing in one context and then to represent before the court something else. I don't think that they would be happy living with themselves as people, let alone trying to win a case.
Other views in response to the question?
Well, I think if you look at the end of Stevens' dissenting opinion in Padilla, it's got very strong language mentioning torture, and I think it's hard to imagine if you just take the Padilla case by itself, nothing else happening during this time, that language would be in there. So I think there clearly was, at least with some of the justices, a response to the ongoing events. Part of what respond to what Neil just said to, I think this has been reported, that there clearly have been some bureaucratic struggles between the Justice Department and the Defense Department about cases like Hamdi and Padilla.
In the White House, too.
Yes, and I think that it's fair to say that bureaucratic agencies always think that they're the best to handle these things, and I think it would not be an unfair assumption to believe the Justice Department would have preferred to prosecute rather than turn people over to the Defense Department to handle. And obviously, defense would have thought that they were the most appropriate to detain. So I think there's with respect to the role of the Solicitor General's office, there's sort of a lot of bureaucratic infighting that plays into this.
Peter?
I want to ask a question that sort of expands the depth of field a little bit. I think Hamdi is and this whole group's rejection of the extreme executive power position is a dramatic and important thing, but there's something in the opinion and in everything you've said that I think is hidden by this debate, and that has to do with the fact that we're talking about minimal procedures for deciding who should or shouldn't be detained, and then the detentions themselves in this case may be for life, certainly are indefinite. And one thing that the Hamdi opinion seems to approve that I don't think has been approved by an American court before is the idea of enemy combatants that aren't either, well, it seems to me that before Hamdi you had to do one of three things with someone you detained. You could charge them criminally, in which case you have to charge them quickly. There's a Speedy Trial Act, there's a Speedy Trial Clause in the Constitution. You could hold them as POWs subject to the Article 5 hearings, not judicially enforceable, but there they are. And they would be held until the end of the conflict, which may be indefinite here, but in conditions including Red Cross visits, letters, packages, medical care, and all this other stuff that makes it not exactly like being in a, I don't know what it's like, but there are some procedural protections. Or you could do what happened to the Kirin people, which is they're unlawful combatants, so they violated the laws of war or alleged to. They're charged, they're tried. A sentence is handed down, in that case death, and there's appeal to an Article 3 court ultimately. In this case, what we're talking about, the only question we seem to be reaching is, well, okay, so I guess we have to have either some kind of quickie military thing, maybe some habeas review, not to determine are they really this person, but to get a rough cut. Yeah, it looks like this person was picked up on a battlefield or whatever. And now the person's going to be held, we call it detention or whatever, till then it may be life in prison. And my question is, I guess is to address that question of what should happen to someone once they're deemed to be an enemy combatant. Shouldn't they have to be put in one of these lawful, unlawful categories, and shouldn't something have to happen next?
Well, I just to make sure I understand the comment in question, you're not suggesting that you think that the plurality approves of an indefinite detention of that person.
They suggest, I haven't read it since it came down, they suggest that if it went on and on and on and seemed fake, that they might take a look at it again. But I don't know how long it will legitimately be the war on terror, and we know that World War II wasn't declared over by Congress until 1954 or something. So I think there's a substantial amount of leeway for holding a person who hasn't been found to be a war criminal, an unlawful combatant, through a finding of guilt, an actual finding of guilt, and who isn't being held in a POW camp for a long time.
Maybe I'm an optimist, but I read the plurality opinion as being more hostile to the notion of sustained detention than just that at some point way down the road they might feel differently. I thought the plurality opinion made fairly clear that they wanted very much to confine their approval to this case, and that was a marker that was laid down not just for future generations, but also probably for for some of the justices in the plurality who insisted that be there. I would guess. But certainly, I mean, I think that concept is frightening, and the specter you raise is a frightening one. And it also, again, suggests a way in which I think the court too quickly stepped around the Endo decision. Because the very nub of the Endo decision was the fact that what had initially been, in that case, congressionally approved, did not contemplate anything like what the government actually went ahead and did on an ongoing basis to Japanese Americans once they'd been found to be loyal. It seems to me that if you take the principle of Endo seriously, then it has to mean more than at some point way down the road the court would be obliged to rethink this. It seems to me that Endo would require that much sooner rather than much later.
John, Neil, Adam, I know we're out of time. Do you want to take time to respond to Peter, or any final thoughts before we adjourn this panel?
Just one thing in response to Peter. This is another situation. That's another question that calls out for regularization by Congress. Authorizing detention, saying how often the question of whether the war is still on has to be reconsidered, a series of things like that. It asks for a statute, and I think with a statute, there would be more deference from the court.
Anna? one thing that's striking in listening to the discussion of the panels is how many issues were left open in the Hamdi, the Patia, and the Whistle case. What kind of process has to provide a Hamdi or an enemy combatant? Can an American citizen apprehend in the United States and be held as an enemy combatant? What kind of procedures have for those in Guantanamo? And though those questions are all left open, I think it's hard to in any way minimize how significant these three Supreme Court decisions were. They're the first Supreme Court cases since September 11th directly addressing questions concerning civil liberties in the war on terrorism. Please join me in thanking the four panelists for a wonderful discussion of the topic.
Thanks to all of you. There are refreshments upstairs on the fourth floor. Let's come back by 10:20, and we'll start the next panel on interrogation techniques.
Thanks, Erwin. My pleasure. Hard sometimes being a moderator, and it's so much to jump in, but it was fun. I really enjoyed getting to do it.
Sorry I was late.
All right. It wasn't ready to get started. Right. Right, absolutely. Well done, well done.
To say nothing of his talk.
Yeah, exactly.
Sorry, what did you say? You're not going to be able to do something? You don't think you'll make a good doctor because...
We're just debating the torture doctrine. It's interrogation. Permissible